Emancipation Proclamation and ensure the passage of the 13th Amendment, both whose stated purpose was to end slavery. The panel that we have this morning will discuss a new dynamic research and evidence that questions if the abolition was the true intent of the 13th Amendment, and if the President Lincoln deserved the right to be called the great emancipator. At this time, I'm going to introduce our keynote speaker for this morning, Mr. Hersy Jones. Before I bring him up to open up the session for us, I'll show a little background about Mr. Jones. Hersy Jones has over 35 years of experience in researching the legislative history of tax legislation, proving the intent of Congress. He was one of the first AA tax lawyers to practice with tax firm in America, being the first AA hired by Roberts and Holland, a Wall Street tax firm, which was the largest tax firm in the world. Hersy has previously testified before the Louisiana House of Representatives Subcommittee on the Death Penalty, providing research that Louisiana originally enacted the death penalty to stop mobs from breaking into jails, to remove and lynch black prisoners, as was a widespread practice in America, including North Louisiana. As research demonstrated, the local newspapers endorsed the death penalty as an appeasement of the bloodthirsty mob. Hersy was a frequent contributor to the Shreveport Times, publishing such articles as the Backing Constitution of the Badge, the death penalty, and appeasement of bloodthirsty mob, Confederate generals who opposed Confederate monument. Hersy has completed several geological research projects, including the history of his great-grandfather's experience in the Civil War, chronicling how he began with the Alabama Regiment of the Confederate Army, but in March 1863 joined the Union Army in Louisiana, eventually referred to as the 76th Infantry USCT, serving first combat of black units in the entire Civil War, in the siege of Fort Hudson in May of 1863, and the last major battle of Civil War was a battle of Fort Blakely in Alabama. The 76th and other all-blacks went to battle before the famed 54th Massachusetts Volunteer Infantry featured in the movie Glory. Hersy was mentored by famed Dillard University professor and nationally acclaimed sociologist Dr. Daniel C. Thompson, author of the Negro Leadership Class, forward by Dr. Martin Luther King Jr., as well as the Sociology of the Black Experience. In 1960, Dr. Thompson, then head of the Sociology Department at Howard University, was handpicked to mentor young Martin Luther King Jr., preparing King for leadership of the Civil Rights Movement. Dr. Thompson, also mentored by Mayor Sidney Bartholomew, Representative Sherman Copeland, Congressman William Jefferson, Dr. Charles C. Teamer, and Vernon Jordan. Hersy was significantly involved in a successful 30-year campaign to remove a Confederate monument from the Caddo Parish courthouse grounds. And during this unsuccessful campaign for sheriff of Caddo Parish, Hersy advocated for ending slavery in the criminal justice system. At this time, please give a round of applause and welcome Mr. Hersy Jones to the podium.
Good morning to everybody. Thank you, Dr. Esmail. Thank you, the panel. Thank you, the Bowie State, for hosting us. And thank you, the audience, for being here as we prepare to present this research. Let me start out by saying I didn't mean to have such a long introduction, but I wanted to kind of lay the foundation. I see you laughing, Candace, but I wanted to have a foundation for how a tax lawyer ended up in this space. And I tell people it was like 3 different routes. The one route was a mentor, not a teacher. I never took a class with Dr. Thompson to do it. But Dr. Thompson was one of the eminent sociologists. Like I say, he was handpicked to be the mentor of Dr. King. And he wrote a book on the Negro Leadership Class, which was a study of New Orleans in the 60s. And Dr. King was just coming on the scene, so to give him credibility, Dr. King did the foreword to the book. And then he hand-mentored him, and he talked about that. So when I met Dr. Thompson, I was an English and accounting major at Dillard. And Cheryl, my #1 focus was how can I make some money? So all this notion about social activism and changes in society was nowhere on my mind. But Dr. Thompson wrote a recommendation for me to Harvard. And of course I got in and I attributed a lot to him. I didn't know exactly who he was at the time. I just know they said he had a master's from Harvard. And so whenever I would come to town, I would go see him, and he would have all these discussions about Black experience and the civil rights movement. Now, I really wasn't that interested in all that, because again, my focus was money. But as a matter of respect, I would listen. But over a period of time, I realized he was depositing in me his focus and his experience, as well as his aspirations and disappointments about where the Black community was going. And one of the things he emphasized was we don't know our history, and we don't know our research, and we don't know the mindset that got us in the space that we ended up in. Most people think it just happened. He said, no, there was an intentionality. And as a sociologist, he was able to study it, and he and W.B. Du Bois and Lee Franklin Fraser and many others, and then they were able to come up with remedies and give leadership. So let's get to our program now. Our program is on unveiling the true intent of the 13th Amendment. And I understand, and I start out by recognizing that when you talk about the 13th Amendment and you talk about the legacy of President Abraham Lincoln, that you're really touching what they call the third rail. That if you want to get blacks and whites, riled up. And my grandfather over here, he bragged that he was a member of the party of Lincoln. And when they chastised him for voting for Nixon, he countered back and no, I voted for the party of Lincoln. So that generation, up until the 1960s, the Republican Party was primarily the preferred party for African Americans, and primarily because of the notion that Lincoln freed the slaves. So to start on that, let me just start with Frederick Douglass' eulogy of the Emancipation Statute on April 24th, 1876. It was the 11th anniversary of the death of President Lincoln. And I'll hide behind Maryland's favorite son, Frederick Douglass, and then as my introduction. Here's what he wrote in 1876. Quote, he was preeminently the white man's president, entirely devoted to the welfare of white men. He was ready and willing at any time during the first years of his administration to deny, postpone, and sacrifice the rights of humanity and the colored people to promote the welfare of the white people of this country. In all his education and feeling, he was an American of the Americans. He came into the presidential chair upon one principle alone, namely opposition to the extension of slavery. And then later on he said, he was willing to pursue, recapture, and send back the fugitive slaves to his master, and to suppress a slave rising for liberty. Though his guilty master were already in arms against the government, the race to which we belong was not the special object of his consideration. This is Frederick Douglass, 11 years after the death of him. And he ends by saying, we were not the children. He said, you are the children of Abraham Lincoln. We are at best only his stepchildren. This is Frederick Douglass. Now, he gave another eulogy within months of President Lincoln's assassination. That's the one I had always read. And that one he said he was a black man's president. He said black people love Lincoln. And he talked about all the things Lincoln had done to free the slaves. So we're here today, and my research will help to explain these two different divergent views. It helps to explain why everybody has different views about Lincoln. Now, Lincoln was at most a preeminent politician. And I've been around a lot of politicians. And the first thing you learn about politicians is do not delude yourself into thinking that you know them. Because good politicians know how to become what they need to become to get what they need to get done. So they may be one thing one day and a totally different thing by the afternoon, depending on the audience. And the most mistake you can make is to say, I know them. And that's where I think President Lincoln was. People have said he grew. And I said, well, how can a politician that's known for being an eminent politician, how can you ever say he grew? You first have to start out with what was the foundation. And then you're going to deal with the change. But if you're dealing with a politician that can change his stripes at any point in time, now you got to ask yourself, what did you really know? And did you know what you thought you knew? So the second introductory comment I want to make is from Senator Daniel Clark. This was made in 1864. He said, yes, sir, slavery in the United States owes its giant growth to the Constitution. Not that it was created by it, for it existed before it, but that it was planted in it, fenced around and protected by it, so that no national power could weed it out short of an amendment to the Constitution. This is after the enactment of the 13th Amendment. So what my research is primarily going to show, everybody has already documented, even the Vernay program, the 13th, on how the accept clause created prison labor. Many books have been written about it. I'm not trying to recreate that. I'm not trying to invade that space. Books have been written to show that how the 13th Amendment primary effect was to re-enslave blacks, athletes. That's been written about. That's not for debate. And that's what the senator said. That although the 13th Amendment is viewed as liberating blacks, it also resulted in what we now call the prison-industrial complex. One article said there were more blacks enslaved in 2007 than there were in 1863. Why? Because of the prison system. So when I looked at these, I approached it from a legal standpoint, and my approach was real simple. Was this intended? Not the consequence of it. We know what the consequence is. We're living it. But was this intended? And could it have been avoided? So in a nutshell, I did what we did as tax lawyers. What tax lawyers are known for, people say we exploit loopholes, and we do. And I worked in New York for the top tax firm in the world. That's why I mentioned that, because we represented some of the wealthiest billionaires in the world. And we're working for billionaires. There's one thing you cannot do. You cannot make a mistake. The second thing you cannot do is you cannot get bad research. So one mentor taught me, and I approached that to this. He said, if somebody asks you what day comes after Sunday, what's the answer? Well, I looked and I said, Monday. He said, bad answer. I said, what? He said, the answer is, I don't know. I need to look at the calendar and see. Because we're taught you can't say something exists until you see it. As basic as that. And to add that joke, one day, Congress passed a bill that Thursday didn't end until 3 o'clock on that Friday. Because they had a bill they had to pass by a deadline. So it's recognized that Congress has the power, like daylight saving time. They have the power to change the cavalry. And so I approached it. So I couldn't say anything, and I wouldn't say anything until I what? Until I saw the research. So I wanted to see, and I went to the legislative history, I wanted to see what did they talk about when they talked about the accept clause. That's what everybody said. Now, I don't want to make the mistake I made when we first did this. Let me read the 13th Amendment. I don't want to assume that everybody knows what it says. Here's what it says. Neither slavery nor involuntary servitude, except as a punishment for crime where the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. That's what it says. Now, I got introduced to this also. I had a client. I didn't do a lot of criminal representation, but I did some with a special favor. And one of my clients I was really beaten down, I always sure gave this basic thing. That if I get you off this, I'm going to get you off. But if you commit another crime, I'm going to get a baseball bat and beat your brains out. That was a trade-off. And he said, why would you do that? I said, real simple. The next time you may rob my mother. You may rob somebody I know. And what I want you out on the street for? So if I get you out, so afterwards, to put me in my place, he said, I bet you don't know the 13th Amendment didn't end slavery. And I stopped and looked at him like, where is he going with this? Everybody knows the 13th Amendment ended slavery. He said, no, it didn't. And I said, look, he said, look, you call yourself a Harvard-trained lawyer and you don't know the 13th Amendment didn't end slavery? I bet you never even read it. He was halfway right. I hadn't read it in so long, so you didn't have the internet then. This is like 20-something years ago. So I went and pulled it and looked at it, and he pointed to the accept clause. And that stayed on my mind. So about 3 or 4 years ago, I decided to take it up as a project. And so what I found, I'm going to get to the end first, then we'll put the background. What I found, that the history of the accept clause, as far back as slavery has been in this country, has always been the same. And that was to target free blacks. That blew my mind. The first slave statute that was introduced in Massachusetts in 1641 had an accept clause. Now, that slave statute is important because Massachusetts was a colony. And when it passed, it was the first one to legalize and recognize slavery. It did not enslave free blacks in Massachusetts. So it wasn't like they passed the law on day one, then day two, every black got enslaved. That didn't happen. What the law literally said was, if you first it started out, let me read it so you can see the similarity. It starts out, and you'll see it sounds like the 13th Amendment. It says, there shall never be any bond slavery, wilderness, or captivity amongst us, unless, it didn't use the term except, it used the term unless. And here was the unless it be lawful native captives taken in just wars, they were natives, or such strangers as willingly sell themselves, that's a voluntary servitude, or are sold to us. The only slaves black enslaved were those already enslaved and brought into Massachusetts. Now, as far as I say, they'll never be. And it's in the accept. So in English, they call that the double negative. And that's what the 13th Amendment used. So in legislation, when Congress uses the double negative, it's designed just like Trump has done with the Big Beautiful Bill. People hear the first part, and they don't look at the details, and they don't realize it's really saying, this is when you can have slavery. It starts out by saying, neither shall there be any slavery, but when you do the exception, it's really saying, these are the conditions you can have slavery. So the 13th Amendment said, basically, you can have slavery if you're duly convicted. That's what it effectively said. Now, the old form of slavery, chattel slavery, ended. But this new form began. So there were many blacks who were, slavery was going to end, and so the criminal justice system became the new middle passage. And here's what I mean by that. Rather than being taken from the shores of Africa, put on a ship and shipped over to America, you could wake up in the morning free, you could get arrested at noon, and you could be a slave by 6 p.m. in America. So the first slave statute in 1641 says, "This exempts none from servitude who shall be adjudged thereto by authority." In other words, duly convicted. So what I wanted to show you first is, this is called the first slave statute. It's in a body of law called the Body of Liberties, which is authorizing slavery. It's not unlike the 13th Amendment, which is called emancipating slaves, but in it authorizes what? Slavery. So once I got past that, now my issue was this intentional? When I first started doing this research, it took a long time, and I can do this presentation, it may take an hour and a half just to lay the foundation. But after the research got crystallized, it can make it real simple. First and foremost, the key to understanding this is understanding the state of Illinois. The Lincoln, I think, what's the motto for Illinois? Land of the free or something like that? Well, Illinois is a key to understanding where we are right now. Because Illinois was a unique state. It was probably one of the most unique states in the country. Because of the way it was created, it could not have slavery. Now, Louisiana and Mississippi, they could vote to have slavery. But Illinois could not. Because the Northwest Ordinance of 1786, from which it was formed from, the land when it was donated by Virginia and Thomas Jefferson, stipulated that any state made from this particular land could not have slavery. So they couldn't even put it in their constitution. They couldn't even vote on it on a referendum and say we want to have slavery. All the other states could, but 4 or 5 states, Illinois, Indiana, Ohio, couldn't do that. They couldn't have slavery. But guess what? They always wanted slavery. So they're stuck with, they could not have slavery, but they always wanted slavery. So what do they have to do? Come up with exceptions. They had to come up with ways to have slavery. And one of the ways they came up with was through the criminal justice system. So they had a statute that basically said, and I'm going to talk about the case, Nelson versus the people of Illinois, which is a key point to the 13th Amendment. Nelson was a mulatto, they said. The statute said if a free black moved into Illinois and stayed too long, it was a crime. Because they didn't want, only blacks they wanted were slaves. If they couldn't have blacks as a slave, they didn't want any free blacks there. So Illinois passed this law that said if you stayed too long, it was a crime. So what was the punishment for the crime? It could be prison, it could be a fine, or you could be sold into slavery. That's 1848. That's Illinois. Their constitution. So Nelson stayed too long. They sentenced him. He sued. Now the irony is, the drafter of the 13th Amendment, Senator Lyman Turnbull, is from Illinois. I'm gonna wait that. Oh, go ahead, keep talking? Okay. Well, he told me every student that came in late would bring me $5. So I'm really not waiting for that, I'm waiting to get my money. So Nelson sued. So Nelson sued, and he said, hey, I can't be a slave, because Illinois Constitution read it to you. Illinois Constitution is very important because it is almost exactly the same as the 13th Amendment. Not exactly the same, but it's almost exactly the same. Here's what it says. It declares that there shall be neither slavery nor involuntary servitude in this state, except as a punishment for crime where the party shall have been duly convicted. That sounds familiar? That's the Illinois Constitution of 1848. That's not 13th Amendment. That's the Illinois Constitution. Now, who's from Illinois you know of? Lincoln. Lloyd in Illinois. You think he didn't know about that Constitution? Senator Lyman, who drafted and went over the Judiciary Committee, who responsible for the 13th Amendment, not only was he from Illinois, not only was he a lawyer in Illinois, but he had just come off the Illinois Supreme Court. You think he didn't know about that provision? So when you look at the legislative history, they say, oh, we got this provision from the Northwest Ordinance, which is the Northwest Ordinance was a foundation for not just the U.S. Constitution, but the Bill of Rights. The Northwest Ordinance is considered the blue standard, gold standard for legislation. So he said, oh, we got it from there. Now, it's similar, but this one is pretty much exact. Now, why does that make a difference? Because one of the number one rules in drafting contracts, and Attorney Higginbotham can confirm this, is you don't want to put a provision in a contract unless you know for sure how the courts are going to interpret it. That's the difference between a good contract lawyer and a jackleg. You know, a jackleg, you don't know, you just read it out. But a good contract lawyer has to know how will this be interpreted by the courts. Now, here's what's key to it. Nelson sued. The Illinois Supreme Court ruled. They issued their ruling in January of 1864. And in the ruling, what they basically said, I'm going to summarize it, is, I know the Constitution of Illinois starts out by saying, neither shall there be slavery nor involuntary servitude. I know that. But it also says, unless they're duly convicted. And what the Illinois Supreme Court said is, notwithstanding this language that said, neither shall there be, the state of Illinois has the legislature has absolute police powers. They can pass whatever law they want, and they can stipulate whatever crime they want to have, and they can stipulate what the punishment. And no judge can second guess that. Everybody hear what I just said? See, the way our country's set up, under federalism, there's certain things that are reserved to the states. And one of the things reserved to the states is their criminal laws. In fact, that's what the slave states relied on to say the federal government can't make me in slavery. Because they said, I got the right to define what's property. And guess what they define as property? Those of African descent. That's the foundation for slavery. Because the state said, we have a right to do this. So when the Illinois Supreme Court did the ruling, here's what it said. In the case of Hells versus Peoples case, it was said that a state has the power to define offenses and describe the punishment, and that the exercise on such powers cannot be inquired of into by a court of justice. In the rightful exercise of this power, the legislature has declared the immigration of persons of color to and their settlement of this state as an offense and declared the punishment. The courts are not authorized to say that such an act is not a crime or that the mode of punishing it is improper, nor have they the right to determine that the best mode of enforcing this constitutional provision or by some other than by punishing the act as a crime. So it's constitutional to enslave these people, even though the Constitution says neither shall there be slavery. Now, why is that so important? Because in January 1864, something else happened. Everybody know what happened in January 1864? They introduced the 13th Amendment. You think that's a coincidence? January 1864, this Supreme Court of Illinois case comes down. January 1864, they introduced the draft bill that became the 13th Amendment. January 1864, it becomes the foundation. They already know what the courts are going to say. Now, the accept clause has another name that I never knew went together. Another name for the accept clause are black codes. Anybody heard of black codes? Right. Now, I heard of Jim Crow laws. Jim Crow laws were laws passed by the South after the Civil War. They didn't mention black. They just targeted blacks. Black codes, though, were laws passed before the Civil War. And they expressly, like the one with the mulatto, talked about blacks. In fact, Maryland had one. And I have it here. Maryland is before the Civil War too. And theirs expressly said, we're targeting free blacks. And Maryland one also said, how they can be sentenced. Some could be sold in the state. It was a real bad offense, they could be sold outside the state. But they could be sold into slavery. So before the 13th Amendment, before all this we're talking about, this practice was already going on. Now the problem was, most of the senators didn't know about it. There's no internet. There's no TV. There's no, newspapers are not being spread all around. So when you get to the Senate and they're having this discussion, guess what Senator Turnbull never talks about? He never talks about this case with Nelson. He never talks about this Illinois Supreme Court case that said, by the way, even though you say neither shall there be slavery, if the legislature wants to, you can sell them into slavery as a punishment for crime. And that's what everybody is talking about as a consequence. But my research is showing this was knowing. They deliberately picked this language. And here's why I say that. Because Lincoln as a representative had drafted a bill early on to outlaw slavery in the District of Columbia. And in the bill he drafted, the accept clause only went to involuntary servitude. It did not go to slavery. In the Iowa Constitution, the accept clause only went to involuntary servitude. It did not go to slavery. The Kansas Constitution, a same thing. So there were other options. And in fact, some commentators have said the accept clause is next to involuntary servitude, and that was really the intent. And other commentators have said, look, the 13th Amendment has never really been challenged in court. And the only courts it's been in have been courts after the Civil War that were controlled by slaveholders in the South. And there were no abolitionists in the South. Did everybody know that? All the abolitionists were in Philadelphia in the North. But in the South, there were no abolitionists, there were no white churches, there was nobody opposing those rich, powerful slave owners who had the Klan and every other police on their payroll. So basically, it's never been challenged. But so here's what happened. In the discussion there's no discussion in these cases. But one senator, Senator Sumner, who's an abolitionist, said, this accept clause looks like it's authorizing slavery. And Senator Turnbull, and Senator Turnbull is a complicated fellow. Well, Senator Turnbull told him, you're being picky about words. Look, the whole point of going to a The Senator Turnbull said, "You're being picky about words." And he said, now Senator Sumner really backed up. He didn't push it. And here's what people suggest. About 8 years earlier, Senator Sumner was arguing with a Senator Brooks from South Carolina. And he insulted one of Senator Brooks' relatives in the whole slave-owning class. And Senator Brooks took out his cane, which he had a metal end, and beat him unconscious on the Senate floor. He was so traumatized by it, he spent months in Paris to recuperate. And while he was beating him, other senators said, "Let them go." This was bound to happen sooner or later. So when Senator Sumner is opposing it, and Senator Turnbull, who's powerful, and Lincoln's right-hand man, Senator Turnbull and Senator Lincoln go way back. In fact, when Senator Turnbull was running for the Senate, he beat Lincoln. And when Lincoln was elected president, he sponsored Lincoln. And there's a letter between the two of them where Lincoln says, "Hey, I trust you as much as I trust my best friend. You don't have to worry about me. We're in this together." So there's no doubt that they were bosom buddies. So when Senator Lyman says, "You're being picky about words, this is going to wipe out slavery, it's going to do the trick," trust me, he's lying through his teeth. He already knows what's going to happen. So the last point to this, to show you about the intent, is after this happened, Maryland started auctioning slaves like they did before. And the Senate got upset about it. And they passed a bill, the House and the Senate, to say you can't have slavery after the 13th Amendment. It went to Senator Turnbull's committee, and he mothballed it. It had never come out to this date. And they said, "What about it?" He said, "You don't need it. I'm going to fix it in the Civil Rights Bill." Senator Turnbull drafted the Civil Rights Bill, and guess what's included in the Civil Rights Bill? That same except clause. So when you add all that together, what you see is the consequence we see that came afterwards was not just foreseeable, but it was intended. And here's what I say was intended. Lincoln was not an abolitionist. He was anti-slavery. Does anybody in this room know what the difference is? I didn't know either. Abolitionists wanted to abolish slavery everywhere. Anti-slavery wanted slavery to stay in the South. They just didn't want it to spread to the North. And Lincoln is on record for that. The Republican Party was formed for that purpose. The platform for the Republican Party, and the commentators always said, it always had two provisions that seemed to conflict with each other. One, they didn't want slavery to spread. And two, they recognized that the state had a right to control its domestic affairs, i.e., its criminal justice system. So when you put all that together, what you get is, when the Illinois Supreme Court made that ruling, they were doing it based on the fact that the state has a right to control our criminal justice system, and I can sentence you to slavery if I like. And the Republican platform had that provision. So they always said, when Lincoln was running, his nod and the wink and his words said to the South, "Your peculiar institution," talking about slavery, "is safe with me. You don't have to worry about me in slavery." Said that is our inauguration. So some say that's why he really got killed. That Booth felt like he had betrayed them. In his last speech, he talked about blacks having voting rights. He had also said blacks don't have any voting rights. In fact, he and Frederick Douglass fell out because he called Frederick Douglass to the White House to say, once we get the blacks free, we got to figure out what to do with them. You know what his recommendation was? We're going to ship them to another country. And Frederick Douglass said, that is the only country we got, Mr. President. What are you talking about? So how can you even propose such a thing? And what Lincoln was basically saying is, Southern whites not going to want you around if you're not a slave, and I don't want you around either. I don't want to have to deal with you. But it'd be unfair to ship you out. So that's the presentation, that's the foundation. And I took the time to lay it out because what I want you to see, I'm not just knee-jerk attacking Lincoln and his legacy. But what we're doing is to make sure that the revisionist historians who did this when there were no blacks in the legislature, no blacks in the Senate, probably any black lawyers, at that time basically said what they wanted it to say. Okay? And so if you go back to the Northwest Ordinance, which is supposedly against slavery, that provision always had the except clause just like the first one. And it also had the Fugitive Slave Act. The Fugitive Slave Act basically said, if you got free from slavery and you ended up in New York or Massachusetts, the laws of New York or Massachusetts would catch you and bring you back. Now it could have said, like the Bible said, if a slave escapes, give him refuge. Don't send him back. It could have said that. And what Lincoln stood for is he was always for the Fugitive Slave Act. And the last thing Lincoln stood for is, if the South has to give up their slaves, they should be compensated. So let's get to the 13th Amendment. They wanted to end slavery, and the South had to give up their slaves. They had to give up free labor. And what was the compensation? That except clause. Because now they gave the South the power. They were going to have to be rebuilt. The war has torn them apart. It gave the South the power to reinstitute slavery. All you had to do was pass a law that said you can't spit on Sunday. Pass a law that says you can't walk on Tuesday. Pass a law that says you can't sleep at night. Pass any law you want, and then send us into slavery. And so when you look at what Eva DuVernay in 13th, and one guy wrote a book on slaves of the state, and all these studies, all they're telling you is that's the except clause. What I'm here to add to that discussion is it was knowing, it was intentional, but yet, as we speak today, it's still going on. Thank you.
Thank you, Mr. Jones, for that outstanding presentation. At this time, we're going to have a panel discussion revolving around many of the comments that Mr. Jones indicated, and we'll open up for questions and dialogue from the audience. Before we do that, I just want to introduce our panelists this morning, this afternoon. Dr. Anthony Jackson, if you want to show them about yourself for just a few seconds.
Yeah, assistant professor here in the Department of Sociology and Child Studies. I also do work for the Prison Education Program, Director of Operations, and happy to be here.
Thank you.
I'm usually loud. So, assistant professor here in the Department of Sociology and Child Studies. I also am Director of Operations for our Prison Education Program here at Bowie State.
Yeah, my name is Michael Higginbotham. I'm a professor at the University of Baltimore Law School. And I'm always happy to be on campus at Bowie State. We have a program that partners with Bowie State. It's called the Fannie Angelos program. And my dad, who's an old school kind of guy, he's a Tuskegee Airman. He always asks me about, how many people do you have lined up for your program? It's a scholarship program where we help people get into law school. and then we pay their tuition, full tuition, $100,000. My dad, I got some big pockets here, right, full of money. My dad said, you must have 1,000 people lined up for the program. And you know what? I tell him, we got a few, but we could use some more. He always said, well, they're not hungry enough. So, all you Bowie students out there thinking about law school, you need to apply to the Fannie Angelos program by October 15. If you're a junior or a senior, because there's $100,000, a pot of rainbow, a pot of gold at the end of the rainbow for you if you're willing to take advantage of it. And you need to talk to Dr. Adams, who has all the information.
Thank you. My first question is a basic question, just the panel's reaction to the research, and did it change your view of the 13th Amendment from how we originally think about it?
We need like 2 mics. First of all, that was a great presentation. I think the language, the verbiage, like how technical, how specific, and I know it probably was tiresome clicking at all those documents, but it was very fruitful because I think that we were all stimulated by it. My view was, I don't think it's necessarily changed. I think that it deepens my understanding of how strategic, how thorough, and how far-reaching this was. I situate, my understanding of the 13th Amendment within a broader structural crisis of capitalism, state violence, and the control of Black labor. So I know that capitalism is always looking for ways to control its productive force, and labor power, working class people being a productive force. And so when we think about what enslavement provided, a class of people that were considered property to be able to use for capitalist productive profit, right? They always need to figure out a way to control that. How do I make sure that I maintain all of the things that are going to be used to maximize my own profit? And so I think I did not know how there were seeds of the 13th Amendment already present, right? And how it culminated to this, and I think that was super dynamic.
So the question was, did I find the research beneficial, and what's my reaction to it? And I found it very beneficial. Anytime you have a professor in the room who's learning some stuff, you know you're speaking some groundbreaking research. And so I would say to you, I like what you said about what day is after Sunday, right? So I think you gave the right answer today. I would say that I'm a real believer in speaking the truth. The truth will set us all free. And that's why today is so difficult in terms of the harm that's being done with, you can't talk about slavery in certain places. You can't talk about DEI in certain places. There's an attempt to muzzle our discussion about our history. And so I think that what Dr. Jones has done, Attorney Jones has done, I think is very, very critical to keeping this discussion, to bringing out the truth, the whole truth and nothing but the truth, right? In my view, we have a birth of a nation, gone with the wind sort of view of our history, and Dr. Jones is making sure that, Attorney Jones is making sure that we get away from that and we speak the truth. As Dr. Jackson has said, and I agree with him 100% in his characterization of the exploitation, especially the economic exploitation that is taking place. I'm a professor of constitutional law, and so I get called all the time. People keep saying, hey, I know your face. And I say, you probably saw me on CNN. And when Trump was president, first time, I used to get a call from CNN every time Trump would say, something racist. And so candidly, I was on, right, once a week for about 4 straight years. So I'm a professor of constitutional law with a specific expertise on racial discrimination, the Reconstruction Amendments. And so what I would just say to all of you is definitely you want to read what Attorney Jones is doing in terms of his research. You want to understand the good, the bad, and the ugly about it all. But our history, as a constitutional law professor, our history has always been that we have laws and we have exceptions anytime it deals with race. And so when Attorney Jones talks about the exception clause in the 13th Amendment, he's just talking about a long history of exceptions, going back to the 3/5 clause in the beginning, right? Anytime you look at Jim Crow legislation, Plessy versus Ferguson, right? There's always an exception. The exception in Plessy was, of course, wet nurses and any assistants could be in the training, even if they were black, could be in a white car. So there's always exceptions, and the exceptions tell you more about the real purpose than the law itself or any statements that the legislatures have made about what their purpose is. So when Attorney Jones talks about the intent of those who drafted the 13th Amendment, and will exclude Charles Sumner, Senator Sumner. I like your reference, because there were some people that were dedicated, and perhaps that beating, altered a little bit of his dedication, but he was dedicated, as well as some others. You can talk about John Brown, you can talk about Frederick Douglass, folks that said, I don't care, you beat me, you can do anything you want to me, but I'm doing the right thing. Do the right thing, right? I'm doing the right thing. And so when you start to think about the 13th Amendment and those who formulated it, that exception clause is very, very problematic. And that's why Attorney Jones's research is so valuable, because that exception clause tells you exactly what the real deal was, exactly what they wanted to do. And so if there's ever a powerful argument, and I've been focused on, okay, lay out the problem, but I always tell my students, you gotta have a solution. I clerked for a federal judge, and his rule was, you can criticize my draft opinion all you want, but you better have a way I can write it better. I can write it differently. And if you don't, he basically said, keep your mouth shut. And so I always tell my students, how can we do it better? So Attorney Jones talks about this exception. How can we do it better? I think his research tells you we need to eliminate it.
Any reaction, Attorney Jones? Any comments before we go to the next question? Okay. Next question revolves around President Abraham Lincoln. I know when I was first introduced this information by Attorney Jones, the whole kind of view. Dr. Jones. Dr. Jones.
We give you honor.
We constitute that today. Our view of Abraham Lincoln, I don't know, it was my shocking kind of thought process when Dr. Jones presented this to me about how we all introduced Abraham Lincoln when we were young kids in school, and he freed slaves, etc. This kind of gives us a whole kind of different perspective on Abraham Lincoln. So just generally your thoughts on Abe Lincoln after hearing Attorney Jones's comments.
Yeah, so I think, obviously, like you, in school, we were taught that he was a great guy, he freed the slaves, etc., etc. But, after doing my own research, obviously, we learned as much more nefarious. So I'll say this, when I think back about the person, I can't take the person outside of the context from which they lived. So I always teach my students about social historical context and how important that is. And when we're reading, we have to read in context. When we're thinking about a person, we have to think about that person in context. And I know that during the era of Lincoln, during pre-Civil War, America wanted to figure out which form of capitalism was going to exist. Was it going to be capitalism based off of industry in the North, or was it going to be capitalism based off of mass agriculture in the South, right? These are ruling class forces that are trying to figure out how we are going to maintain power, how are we going to construct a capitalist system that is designed to make sure that our interests are protected. Well, slave labor at the time, in many ways, was competing with wage labor. You have historic resentment that white folks have had, white working class people had with black folks, because they felt like, just like, today, they were taking all the white jobs. Now Trump said they're taking other folks up and taking all the black jobs, but playing working class people against each other was very strategic, because you don't point the finger or look upward at the ruling class strings that are being pulled. And so when I think about Lincoln, and I think about who he is, and I think about the intent, I know from research that it was all about preserving the Union, and it was all about making sure that capitalism was going to not just survive, but thrive. Wage labor competes with slave labor. You have to have a class of people that are going to purchase the products that you need to sell, right? In so many different ways. And so, what was going to happen? So it led to a civil war. And when I look back at some of the direct quotes that Lincoln said, and I wrote it down, if I could save the Union without freeing any slaves, I would do it. If I could save it by freeing all the slaves, I would do it. And if I could save it by freeing some and leaving others, I would also do that. What he knew about slavery is all about preserving the Union. He also said, I am not, nor have I ever been, and you got this in your presentation, haven't been in favor of bringing about in any way the social or political equality of the white and black races. I am, nor have I ever been in favor of making jurors and voters and Negroes. He continues to say that, and him, so much as any man during the time, think that there is positions of inferiority and superiority when it comes to the black and white races, and he was in favor of the superior position being assigned to the white race, right? This is who he was. It was a man in the context of enslavement, in the context of how to control labor, right? And so when I think about Lincoln, I think about how he is a person that sit at the helm of a machine, a capitalist machine, right? And so I always want to say, we have to be careful in how we think about an individual's role, even though it is very important. But if we think that the person themselves is the problem, and we don't look at the systemic challenges that are arising, then we do a disservice, because we believe that if we switch the person out, then, maybe things will be better. But, there are so many presidents that we've gone through. The 13 minutes still existed. And then through so many eras, capitalism is going to find a way to preserve itself, to make sure that it protects its interest. And so I think about Lincoln in that context, and just thinking about the ties. You did a great job, I think, with uplifting how embedded not just the ideology was, but how, they bumped elbows. You talked about how, I wrote his name down, Turnbull was homeboys with Lincoln. They all was homeboys, right? And when one opposed one another, they fight it out, but nonetheless, the structure, the systemic issues, the challenges, that still stands. Because here we are today still talking about the 13th Amendment.
I agree with Dr. Jackson completely, especially when he said about, he's not surprised when he heard about Lincoln. It just kind of reaffirms what he already knew. And as an elementary school student, just like Dr. Jackson, I was told Lincoln freed the slaves, and how wonderful he was. But as a professor, somebody who studied in this area. What Attorney Jones said just kind of reaffirmed my view of Lincoln. He's a politician, as you mentioned, and it just kind of reminded me when I'm hearing about Lincoln and his ambivalence or lack of taking a strong position on the immorality of slavery anywhere. It just kind of reminded me of what Lyndon Johnson was doing in the 1960s, the civil rights movement, you know? Dr. King and other civil rights leaders, and we're in the King building, right? Is the King building? Oh, it's next door, okay. Almost where, that's where I went first, when I couldn't find the spot. But King had to push Lyndon Johnson, Douglas, and other abolitionists had to push Lincoln to do the right thing. And, I feel like, in one respect, I feel hesitant to criticize Lincoln too much, and I'm going to tell you why. He deserves our criticism, but not too much. And the reason why, I feel like the slave preacher who first heard the Emancipation Proclamation for the first time. And he said, Lord, we ain't what we ought to be, we ain't what we should be. We ain't what we're gonna be, but thank God we ain't what we was. When I think about Lincoln and the 13th Amendment, I'm like, thank God we ain't what we was, because while it's very problematic, as Attorney Jones has laid out, it's not as bad as what we was. And so, when I look at Lincoln, I wish he hadn't been assassinated. Because as Attorney Jones said, he might have listened to Douglas on a number of things. And so it would have been interesting to see what he would have done. Would he have signed that 40 acres and a mule legislation put forward by Thaddeus Stevens? Would he have signed that so that my dad and others wouldn't have to walk around talking about I never got my 40 acres and a mule, Would he have supported all of the radical Reconstruction legislation that Charles Sumner, Thaddeus Stevens, and other committed individuals to racial equality? Would he have signed that legislation and championed it and enforced it as it never was? I mean, that would have been something to see. And then we could sit here and talk about, things might be a little bit better than they could have been. And so when I think about Lincoln, that's kind of my conflict. That's kind of my tension. But I agree with the research that we got to be critical of what Lincoln didn't do and the positions that he didn't take.
Professor Dr. Higginbotham, that's why I started out with Maryland's native son. Because he knew Lincoln. He lived with Lincoln. And that second eulogy is 11 years after Lincoln's death. And in the rest of it, and I'll ask you can Google it, he says, I'm thankful for Lincoln. Lincoln was the right man for the right time. Because he knew his country. And Lincoln was it's kind of like I tell people about Trump when I get upset about this. People get upset with me, and I said, now, you got to understand Trump. And I said this way back before he was elected. I said, Trump believed in one thing. Trump. He told everybody what they wanted to hear.